And the last point I already mentioned is partial access. If we can give out part of a document, but not another part, then we have to provide partial access. So you get a document where the sensitive parts, the parts which are covered by exceptions, are covered, are sort of blanked out. In the Council we have the practice to then also make that partially accessible version available on the internet. Again, on the principle that if we give it out to a particular citizen, we give it out to the whole world without distinction. Now, there has been, and I think Marc will talk about it in more detail, a proposal from the Commission to revise Regulation 1049. I won't go into much detail there myself. What has been the biggest change in the last few years, however, has not come from the legislator but more from the courts. And I'll run you through 5 major judgments from the Court of Justice from the last 3 years, which have in a way completely rewritten the law on public access of documents in the EU in a rather dramatic way. And 3 of those judgments were from last year. The first one is the International Federation for Animal Welfare, IFAL, judgment from 3 years ago. And that concerned Articles 4.4 and 4.5 of the regulation. If you have the text, you can look it up. And that's the problem of what to do with documents that have been drawn up by third parties. And especially what to do if that third party is a member state. And the regulation says there that as far as third-party documents are concerned, the institution shall consult the third party with a view to assessing whether an exception is applicable, unless it is clear that the document shall or shall not be disclosed. And then paragraph 5 says that a member state may request the institution not to disclose a document originating from that member state without its prior agreement. And for a long time it was thought by not only the member states and the institutions, but also by the Court of First Instance, that this meant that the member states had a veto, right of veto, and it's certainly what the member states, I think, signed up to in 2001 and how they understood it. That they had a right of veto to say that no, we don't want you to give out a document. We have drawn up the document. It falls under our own domestic legislation on access to documents. In Ireland, it would be the Freedom of Information Act. And it was certainly in the Council kind of seen as a demarcation line to sort of mark off where national laws on freedom of information or freedom of access to documents end and where European law starts, and to have a sort of boundary line in between. That was not the view of the Court of Justice, which in a landmark judgment said that, well, it's true that the member states have a right of to ask not to disclose the document, but they must give reasons for doing that, and they must say which exceptions apply, and they must point to exceptions within the regulation when they do so, and otherwise they don't have the right to do that. And the decision then taken is essentially a decision taken together by the member state concerned and the institution to grant or refuse access using the exceptions in the regulation. So the court really tied that right of veto in inverted commas, to the exceptions. That was one change. The second landmark judgment, and time limitations require me to be a bit fast here, I fear, was the Turco judgment, where the court said that concerned access to legal advice given by the Council Legal Service in a legislative procedure, where the Council said that, well, you have to, in legislative procedures, the principle is transparency, and only in very exceptional cases can can the court accept that a document would be withheld, that legal advice given by the Council Legal Service would be withheld in the context of a legislative procedure. That was the second major case, which on the technicalities kind of rewrote the regulation to some extent, I must say, because that was not at all evident, at least not to the Council. Certainly not to me, I pleaded the case. The third and fourth cases I will take together were from last year, and that is a case called TG Ilmenau and API. And the first concerned access to the file in a competition law case, and the second access asked by journalists to briefs which were submitted by the Commission, or received by the Commission, I think submitted by the Commission, in the context of court cases, court proceedings in Luxembourg. And there the court took a line which was radically different from Turco and really distinguished from Turco, and said, well, on the one hand we have legislative cases where the institutions act in a legislative capacity, where in principle there has to be full transparency. On the other hand, in competition law cases, it concerned a state aid case, the rules under state aid law for access to the file are extremely limited, and the rules of public access have to be interpreted in line with those rules. And for in the API case, they took the same approach and said, well, in principle, there is no access to the file for third parties in ongoing court cases, because that would impede the proper administration of justice. And therefore, the court proceedings exception in the public access regulation has to be interpreted as not giving more access than what the rules of the court allow. That's essentially what it amounted to. And the fifth case, and I really have to be brief here, so if you have questions later, then I'll be happy to answer them. The fifth case concerned Bavarian Lager, and that concerned the relationship between, on the one hand, the public access regulation, and on the other hand, the data protection regulation. Now, the data protection regulation foresees all sorts of restrictions and checks on the handling of personal data by the European institutions. And the principle there is that personal data are protected unless, on the other hand, public access regulation has this principle that documents are public unless. And Article 4.1b of the Public Access Regulation says that the institutions shall refuse access to a document where disclosure would undermine the protection of privacy and the integrity of the individual, in particular in accordance with community legislation regarding the protection of personal data. And there was a lot of discussion between the institutions, and I'm sure that the Ombudsman has something to say about this, on exactly where the balance had to be struck between those regulations and how Article 4.1b had to be interpreted. And the court, in the end, took what I personally think was a very sensible approach, and said that, well, if you get a request for public access to a document that contains personal data, you have to follow the rules of the data protection, the regulation, and that is how it interpreted Article 4.1b. It follows that where a request based on Regulation 1049 seeks to obtain access to documents including personal data, the provisions of Regulation 45, that's the data protection regulation, become applicable in their entirety. So that is those are kind of 5 judgments where a lot of the outstanding issues have been dealt with by the courts, but which have led to a distinction in the case law of the court between the institutions acting in a legislative capacity and the institutions acting in a non-legislative capacity. Frankly, the basis for that in the text of the regulation is very slim. That all rests, I think, on a rather tender basis in the recitals, but it's all constructed by jurisprudence, if you want. But that has kind of given the practice of access to documents and transparency in the council or in the institutions a rather different flavor than, or a different kind of flavor than what it was 5 years ago. That is, I think, as far as I would want to leave it.
May I ask whether, in your estimation, it's a positive different flavor or a negative different flavor, if you'd like to say that?
Again, speaking for myself, not for my institution, I must say that I can understand that, for instance, in the TG Ilmenau cases, competition law cases, where I think the Commission had to deal with, in one case, requests involving 47,000 pages of documents, where the Commission in principle has to deal with that within 15 working days, extendable with another 15 working days. I believe there have been cases of law firms deliberately asking for massive amounts of documents simply to stall procedures as a sort of procedural stratagem. This is the point where I think the court has a point in saying that, listen, this is not what the public access regulation was intended for. It was not intended to be a sort of procedural kind of stratagem for law firms. It was intended for citizens to know what is going on in the EU and to be able to influence that. So then in its result, I must say I can see merit. In terms of the precise, the way how the court has reasoned it, with the greatest respect for the court, I think that here and there there would have been room for improvement, but it would take me a lot more time to actually explain that, so I'll leave that for the